Okay, so civil procedure rules go to the website. They're listed there and they're updated there. Okay? And what you can do on the website, it's easy to press Control F, put in what you're searching for, and it'll very quickly go through there, as opposed to flicking through flipping thousands of pages. Right, when you're referring to civil procedure rules, and why would you want to refer to civil procedure rules? The reason you want to refer to civil procedure rules is because the objective is to move the court to do what you want it to do. Okay? You've got a contract that they will uphold these rules. These are the rules of the game. Okay? And so the contract is, if they don't follow the rules, then they're in breach of contract, and therefore you have right of appeal. You have right to remedy. Okay? Now, are you obliged to follow the rules? No. Why? Because I'm not an officer of the court. So, like with Calvin, what we did was, he put in, I can't remember what he said, an objection to the order or something like that. Okay, he didn't put it on the N244. Why did the judge agree? Because equity over substance is what counts for us. But for his guys to do that, they wouldn't get away with it. Why? Because they're officers of the court. So they are obliged to follow them. So basically, the way you refer to it is CPR, Civil Procedure Rule, and the rule number. If it's criminal, the criminal procedure rules, it's crim PR and the number. And then you'll see what they've got in the rules is they've got an explanation as to how to use it, and that's called the practice directions. So some of the rules have practice directions. Okay? And so when you look at an order, they'll say, in accordance with this section, blah, 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 we're looking for the case to be struck out because it doesn't meet the statement of case in accordance with CPR, blah, blah, blah. Okay? So if you've got legal representation, this is all they know. However, if you understand the rules of equity prevail over this, you can get substance. I've had 2 times where they've asked me to resubmit my statement of case on applications where they asked for a strikeout. Okay? Why did I get that? Because basically I was arguing equity, substance, what was coming out of my mouth. I might not know the form that you guys are dealing with, but that ain't my problem. Okay? So Calvin's got exactly the same result. So not only have I got my own experience, we've got Calvin's experience. It's equity, substance over form. But we can use this in order to force the court, because remember, what we do is when we put in a request, we put in the remedy that we want with our complaint. Okay? That's what we want the court to order. And therefore, what we're doing is, where possible, okay, is helping the judge give us what we want. We don't want to be sitting calling him an idiot and this and that and the other. We want to give him the tools. We want to open the door to help them give us what we want. So it's not very difficult when you understand the most important rules. So very quickly, CPR 1. This is the most important thing. It's to deal with the overriding objective. So anything which prejudices, basically, to deal with the case justly. All right? So it's all equity. Why? Because the word justly means equity, what is fair and just. Right? But it goes on immediately to contradict itself with proportionate cost. And what they try and do is to strike out cases. They say, oh, it's only a £5,000 claim, but it's going to cost $50,000 to go and litigate it. Okay? Nothing just about it. Why? Because law is fundamental. It's not a question of money. So wherever possible, you quote and go back. Any action which is done which is not just, you turn around to the opposition and say, their action is not unjust, they're in breach of CPR 1, and therefore I require the court to take action to correct that. So honour, my word is my bond, good faith, I don't put my self-interest above that of another, and clean hands, I do everything openly, honestly, transparently, because otherwise I'm attempting to commit a fraud. We said about service of documents, so that's CPR 6. Every party in a case must be served. It's no good just serving the prosecution or just serving the court. Everybody must be reading off the same hymn page. Now, what's important is disclosure. What you're trying to do is make sure that you get the evidence you need by forcing disclosure. So CPR 31 is disclosure, and you'll find the stuff there. Now, obviously if they haven't got it, they can't give it to you. But then they need to give a good reason if it was with them as to why it's no longer with them. So this details different parts of disclosure, and I think it's 6. 3112 is for specific disclosure or actually asking them to produce original documents. So this is the stuff that people, and we're starting to use it now, to try with the mortgage fraud or loan fraud. Okay, show us the contract. Because no barrister has forced another barrister to bring this stuff into court. So using this, we are starting to force disclosure. And there's this brilliant one called 3116. What we can do is, if we believe that a document exists, before we even bring a case, we can put in an application to the court to force them to produce that document, in order to avoid wasting the court's time, as this might help us resolve the dispute in private. So what we're doing now is under 31.6, we're putting in for loans and mortgages, we want full, accurate and complete audit trail balances showing every single transaction relating to a mortgage. So, and hopefully we'll have the first one where we get a court order forcing a bank to disclose all the accounting entries, double book entries, so that we can trace where does this alleged loan come from. Okay? So we've got incredibly powerful tools for this. Right. Now, they cannot, so practice the direction 31.4 creates an obligation on solicitors, okay? They must act honorably, clean hands. The concept is the rule of law is their overriding objective, and cases must be dealt with justly. Therefore, if a solicitor or a barrister knows of a document that will avoid a case going to court, they are under legal obligation to disclose this. You can't turn around to say, oh, well, I'll check with my client whether I can or can't. And guess what we've got there? What did Natasha say? I will check with my client whether I can or can't disclose this. Put this
whether I can't include it in the bundle.
Whether I can include this evidence in the bundle or not. Clear breach of the rules. Okay? So, this is the way they do it. They basically, if we don't know the basics of how we're defending ourselves, forget it. We're running blind. So, what I've gone through is really concentrated on the rules of disclosure and evidence. We can actually put in an application asking them to admit to certain facts. So I think, Calvin, we put in that one, didn't we? Can you please admit that the Bill of Rights is current statute law, the Act of Settlement. So we put in for the three fundamental documents that we're relying on. We've asked them to admit in advance that this is fundamental, current statute law. We haven't told them why we want it. We've just asked them to admit to the fact now. Okay? So it's important that we use the tools we've got, and remember, it's about trying to resolve dispute. We want to resolve dispute. They have the conflict of interest. If they resolve dispute, they don't make any money. Okay? So with the simple tools, like I say, there's 7,000 odd pages on the civil procedure rules. We don't need to have all the knowledge of all of this. None of them know all of it. They know only specific parts of it. Now, hearsay evidence, there's a lot of interference on the criminal side with this. Okay? Because what they're saying is, oh, well, if Parliament decides that this is okay to enter into evidence, right, it needs to get into evidence. Okay? Hearsay evidence is quite simply, the Bible's an example. Why? Because somebody cannot stand and speak it into existence today. What's written down there? It's just a story. Who knows the veracity of its truth or not? Okay? So, we can throw out hearsay evidence, and a huge number of cases, they will introduce so much hearsay evidence. If there's not a person that will go into that witness box, speak that evidence into existence, which you can cross-examine, that should not be allowed in a court, and you must object to it. So again, it goes through that. So that is with the civil procedures, what's important? Forcing disclosure. So the criminal procedures have the same effect, but because they're a bit more specific, okay, it's all covered in the criminal procedure rules. Again, equity applies whether it's a criminal matter or a civil matter. It makes no difference. Equity prevails. Okay. We've talked about the Sentencing Act 2020 and harm. So with the overriding objective is slightly different on the criminal procedures. On civil matters, it's the balance of probabilities, which means, is there a 51% chance as opposed to a 49% chance? Whereas the overriding objective on criminal is that cases are dealt with justly. Nothing about money in this. Okay? The objective is to acquit the innocent and convict the guilty, and dealing with all parties fairly. It doesn't matter if you're a legal professional or a litigant in person. Yeah.
As far as I understand, civil is balance of probabilities, criminal is beyond reasonable doubt.
Correct, yeah. Okay? And with criminal, they must recognise the rights of the defendants. So you've actually got quite a strong tool, again, under the overriding objective. Basically, is there anything which biases one party or another? Right? And that there is the most powerful tool for that. Remember what we said? Not only must the rules be observed to the letter, but to the spirit. So what is the intent behind the rules? The intent behind the rules is to make sure everybody's singing off the same hymn sheet, got the same evidence, got everything that they need, and based upon that evidence, the court can only make its judgment. And the legal advisors used to be called clerks. Bugger off. bloody links in here. Don't know who put all these links in. Their job is to provide the court with all relevant law. Okay? So what does that mean? It means if you've got a question of law, the clerk must answer your question. Whether it's a question of law or procedure, anything that's got to do with the case before the court, litigant in person, you flip and ask the magistrate, not the magistrate, the legal advisor. Okay? So they'll turn around, the judges will turn around and say, my job isn't to advise you on law. It's the legal advisors. So and this is from them, any point of law that is or may be involved to any question arising in the proceedings before them. The whole idea is to narrow the issues before the court, and what they're trying to do is resolve as much as you can in private, and that includes everything to try and settle the matter outside of the court by consent, okay? So that the court only has to deal with the true issues. And this is what comes in with the point-by-point thing. When you make your claim, you say, point number 1, point number 2, point number 3, point number 4. So in the civil case, so with Ahmed's case, he had 30 points. They answered one of them. They didn't even address any of the other 29. So, what they submitted as a defense to try and get us to drop the case is simple. You have failed in your obligation to admit, deny with counter evidence, or ask for further evidence from me to prove a point. You are in breach of the rules. Therefore, you are obfuscating, and therefore creating a dispute where none exists. Okay? So this is really powerful stuff that we can use against them. In both civil and criminal, you need to be able to prove service if it does become a question, and this can include basically a certificate. Okay, what's a certificate? A certificate is a statement of something that occurred. So a birth certificate is a statement of the event, or it could be called a stock certificate, and it wouldn't be called a birth certificate, it would be a stock certificate with your name on it. Okay, part 5 is the what must be supplied to the two parties, and anything which you think that you need to ask for. The rules cover sound recording, and basically, like we've looked at before and said, it's about ask permission, and they need to give you a reasonable excuse as to why you shouldn't be allowed to record. Let them. Don't you sit and argue. You just say, look, I'm the only one that can be prejudiced. I have the right to my self-defense. For that, I need a recording. Anybody got a problem with it? I.e., you got a problem with it, now prove that my request is unreasonable, if you object to it. If you can't prove that it's unreasonable, the court can't do anything but to, except to allow you to record. Part 7 is how to start a prosecution in the magistrate's court. Part 8 deals with basically the initial prosecution disclosure. And what they do here is, and this again is something that we need to start using, what they do is, they might take 3 months or 5 months to provide their evidence of their claim against you. These are legal professionals, so therefore there's nothing unreasonable of you saying, well, it's taken you professionals 5 months to do this. I'm a layperson. I want a 15-month adjournment on the case. How can they unreasonably refuse that? They can't. Okay? So we can start to use this knowledge and to our advantage. Your right to trial by jury is something that legislatively, i.e. interference by Parliament in the independence of the court, are trying to manipulate and deny you your rights in the Bill of Rights, which they are meant to uphold and ensure for everybody, to trial by jury if you want trial by jury. Okay? So that there is something, if you believe in trial by jury and want trial by jury, that part you'll use for it. So forcing disclosure, okay, in part 15 explains how you can force disclosure in a criminal a criminal case. Now, the footnotes say to disclose prosecution material not previously disclosed that might reasonably be considered capable of undermining the case for the prosecution against the defense, or anything assisting the case of the defendant. Okay? It's very clear. If there's a suspicion of bias, it needs to be dealt with, otherwise it's a contempt of court. So in a magistrate's court, as soon as it's reasonably practical, after a pleading, or in the Crown of Court, if it's been committed to trial, what they have to do is, if you have a belief that there's something that they have that is not in their disclosed evidence, okay, then you simply ask for it. So what started all of this? A request was made for the telephone. Reasonable grounds for it is, I believe, or Calvin believed, this will exonerate him, i.e. this here will assist me. And not only that, it'll totally undermine your case. Okay? So that alone should have resulted in, okay, a certificate. If there is no such material, then the prosecution must provide a certificate to the court. So what should have happened was, this question about evidence was brought up. The prosecution should have said, yep, in accordance with rule number da-di-da, the court must adjourn the case. I need to go and verify whether this stuff exists or not, and if it doesn't exist, I need to come back and give you a certificate. That's what should happen. That didn't happen. So what should have happened next? The legal officer should have said, hang on, you've got to adjourn the case until he's verified this. The court didn't do this. Instead, the legal advisor and the prosecution colluded, okay, to say, oh, don't worry about it, we don't need to watch that video. Okay? So that there is a clear contempt of court, therefore the conviction is unsound, end of.
Mark, is this criminal?
This is criminal. Okay? So there are powerful tools to force disclosure. Again, hearsay evidence, what they've actually got in the criminal procedure, it's in favour of the government. Okay? But that there, if they follow that and are showing bias, that automatically shows bias, therefore unjust conviction. How can it be beyond reasonable doubt? Okay? So if they're trying to enter hearsay evidence, that means you cannot meet the standard of reasonable doubt. Okay, so that there is the basis. Remember, it's about the evidence before the court, so we've got some really simple and powerful tools where it doesn't take a lot. We can quote their rules back to them and help the judge and force the judge or move the court to give us the order that we want. Right? So that's one way where we can start holding it to account. So we talked about the default judgment earlier, that if you do not engage, you will end up with the default judgment. There's a lot of talk going around about this thing called the void order. Basically, anything which is bias results in a void order. And basically, a judgment which results from an unfair trial is a judgment written in water. I.e., if you can show any bias, any fundamental flaws, then that order is void. I don't want to talk more about void orders because you may need to go into what was brought up here. If an order has been made through an appeal, it can be voided. Okay? So I've called the next bit into the snake pit. Okay? And this is really the crunch of how we're going to start holding these people to account. Okay. Okay, so this is really what it's about, of what, what I see as a solution to hold these people to account. So what you got there is basically a 6-page thing, which goes through step by step what should happen. We've talked about the equal treatment bench book. Okay, this little document. Right, there are other books with it. So we can use these tools again to our advantage. So within there it says about their oath. I will do right to all manner of people after the laws and usage of the realm without fear or favour. In the introduction 1 it says, I will treat everybody fairly and equally. And this is part of their training guidance. So we use this. Equality. Understanding means understanding the evidence, the materials, the process, the meaning of questions, the answers to them. Remember when we looked at the obligations of the officers of the court, all right? It is to use plain language. So when they're asking, do you understand? What are they asking you? Do you understand? Do you comprehend? Not do you stand under me? Why? There needs to be a meeting of the minds. If there's not a meeting of the minds, it's void. Okay? So wherever we look, we've got this. So the whole thing about legalese, jargon, courts talk a different language, they try and trick you, all of this is not supported in evidence. Okay? And at 62, the judge is the facilitator. Alright? And the obligation is to ensure that you understand through the use of plain language. Okay? Now, what's important is when you use this, section 63. Okay? So if we start with this thing that I gave you, the first point. Now, the idea of this is to create a record of what you evidenced at the time. Okay? Because I can assure you, if I asked you, what did I start with after we've got together a few minutes ago, whatever it was, we will have different stories. Therefore, it's important to write down at the time. Okay? So, the idea here is, if you've not got enough space, each box is numbered, you write on the back the box number and you carry on where you need more space, so that you've got everything together. The first thing is you want to know the court name, the court number, you want to know the case number, the date, when it started and when it finished. So, first thing of it is public access. Was there an issue of anybody getting into the public gallery? Yes or no? If not, if it was a problem, who created that problem? Get their names and the reasons why they were denied access. The complainant, who is the complainant, who's their representative? Who's the defendant, who's their representative? Okay? So this here is what information generally you should be able to get before you go into the court, with the exception of when it actually commenced and when it finished. Now, you need to know who is making judgment, who is present in the court, okay? And so you need the legal officer's name and the magistrates and the prosecution. They have been extremely reluctant to give out this information, okay? And this has been really good. Quite simply, by doing this. Is the bench familiar with the Equal Treatment Bench Book? Okay? Now, in the first set of council tax hearings in Malden, what happened was, they asked the judge for their name. I can't remember, I think Angela was first. And the judge refused. Or the magistrates refused to give their names. And they said, oh, but you have to. And they still refused. Anyway, when Chrissy was next, he turned around and asked, what are your names? And they refused. So Chrissy called, at the time, actually called out the case law. Okay, and what it is in box 13, the case is Regina versus Felixstowe, and it says there is no such person known to the law as an anonymous justice of the peace. Can you please give me your name? So Chrissy had told the magistrates the law, and they said, no, not giving you my name. The legal advisor turned around and said, you have to give your name. He's just giving you the case law. I've made my decision, I'm not giving my name. Okay? This is the nonsense that you've got to put up with. So, as a result of that, the section 142 that's going in is all of the council tax orders that were issued on that day are void. Why? Because they failed to follow the due process of law. They had no authority not to give their name. Therefore, they acted outside of the authority of a lawful court. Therefore, everything is void that comes out of it.
You have to give their full name or just their first name or second name?
Okay. So, if you go through the Peacekeeper course, why do we need people's names and addresses? The police come up and say, oh, you've been loitering in accordance with blah, blah, blah. What's your name? Okay? And you say, well, show me the evidence. And if they show you evidence, you decide whether to give your name or not. So, why do they need it? If you want to avoid going to jail, okay, or them arresting you, just give them your name and address.
No, I mean the judges.
No, the same reason,
Okay.
same thing, okay? Once they've got your name and address, that's it, end of. If you believe that I'll be loitering or doing this, that, or the other, go and serve your flippant claim in the courts, leave me alone, bugger off, stop breaching my peace any further, because the courts determine guilt or innocence, not you, Mr. Policeman. So, just by giving your name and address, that's it, end of.